Well, hello, Lyric Armstrong, your real estate agent and advocate. We are here. We're getting back to one of my favorite judges. We've gone and seen a few of our other judges, which was Judge Catherine Sala or Sala, and of course Judge Simpson. But today, Judge Middleton Day. Got to catch up with Judge Middleton. He has a lot of great things going on. So go ahead and like, share, and subscribe. And we're going to go ahead and get into court. We are here, Judge. Yes, we are ready for court. Oh, wait, did I take care of my housekeeping is light? Let's go ahead and click that like button. And we are going to be going over some zoning matters. And what does that mean for you as homeowners? And then in some regard, tenancy, but this is really specific to homeowners. We'll talk about how it affects tenants in just a minute. All right, here we go.
Gentleman was picked up early here today, so.
Well, let's speed them up just a tad bit so we don't have to be here long. There we go. Yes, Judge. Oh, look, Judge. Okay, so the judge has a QR code public satisfaction survey. Okay, fill out that code and make sure you tell them how satisfied we are. Because it's awesome that Michigan Court and Judge Middleton specifically is allowing us to get on Zoom and witness the court activity.
All right, we have two zoning violation matters scheduled,
I can't hear a thing.
and they just handed me a Polycom. Sharon Miller is here, and we'll address her here in just a moment. But the first matter we're going to address is City of Three Rivers and Willie Thomas. Mr. Thomas is the title holder to a property on Jefferson Street in Three Rivers. And we've discussed this a couple times. It was at one time a fine home. It's in disrepair. Mr. Reed, what's the status here today?
Thank you, Your Honor. The last time we were here, there was a finding of responsibility or admission of responsibility to the violations. We waited more than the 21 days for the appeal process. At this point in time, there has been no compliance. Joe Klein from Safe Built, who is the contracted inspector for the city, is here willing to testify that the property remains in the same condition it was when we were here before, and we're asking the court enter a compliance order requiring to be brought into compliance within 30 days. If the value of the cost of bringing it into compliance exceeds 120% of the value of the home, that it be demolished and razed.
Who would own the lot?
The defendant would still own the lot, and then obviously be assessed back on the tax roll for the cost of demolition. And if he redeemed and paid the taxes, that would be fine. He could continue to own the lot.
Mr. Klein, would you raise your right hand?
Yes, Your Honor.
You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, Your Honor.
You're an actual employee of Safe Built, but are you actually assigned to the City of Three Rivers?
Yes. Yes.
As their building inspector?
Correct.
And you have testified previously about this property on Jefferson Street, most recently in April of 23. Has anything been done to the property since that time?
No, Your Honor, it remains in the same condition. We've actually had some homeless people move onto the property since then, actually, coming and going, I should say, on the property. But other than any improvements, no, nothing's been done that I can tell.
I was going to ask if some of these abandoned houses then become homeless magnets. Mr. Dutka, what's your position here?
Your Honor, first of all, I have to again reiterate something we brought up a long time ago in this matter, and I've discussed it with Mr. Reed. It's the way the case is captioned, and it's even the way the case is phrased by the court. There is a co-owner here, and even Your Honor
Yes.
talked about this in the singular, and it should be in the plural. We have no knowledge as to whether or not Maurice Thornton was ever noticed for this hearing or actually for even the very first hearing on this thing. I know we did not contest it, and we appeared with Mr. Thomas live in the courtroom. Well, okay, that's part of the problem. We still have a co-owner that we have to deal with. And I can inform the court as to the progress we've made with the partition case. That's been a problem with Mr. Thornton, and the post office and process servers and the like. We eventually got Mr. Thornton served, but in that partition case, and what we had to do eventually was to get a separate court order from Judge Stutzman for alternate service because the man wouldn't come to the door of his premises in Chicago. And so he was properly served pursuant to Judge Stutzman's order alternately or alternatively. And we waited the 28 days, which is what the court rule requires when you're served out of state. And I filed the default on this case just about a month ago. I think it's the first part of August, if I'm not mistaken. So we've got a default against him. The next thing that Mr. Thomas has to do with regard to the partition case is to file a motion to have the court appoint a receiver. And that's been my fault. I haven't been able to get to it. It's a little bit of a job to draft one of those, especially when you have no office help. But on the other hand, that's my lot in life. That's my choice. But anyway, we're at that stage, and I think with a little bit of time, I'll get that motion filed. I don't know who Judge Stutzman is going to appoint as a receiver, since I've been doing a lot of the receiver appointments. Obviously, I can't be that and represent Mr. Thomas at the same time. But in any event, what I guess I'm asking for is, in pointing out the issue with regard to the co-owner, Mr. Thornton, I'm asking the court for more time. We'll get the motion filed. We'll get a receiver appointed, someone, I don't know who. And what I'm fearing in this case is that if the city decides it wants to raise the building, well, we're talking about just the value of the lot, and I don't know if there's going to be anything other than an abandonment of the property to the city for non-payment. I think from all indications I've had, the property is savable. I know I've furnished my client a whole laundry list of local building contractors, and I think he was lucky to have a couple of calls returned. And when they found out about the job, they weren't interested. That's, I guess, where we're at. We tried to comply with the order as best as we could.
You raised this at our very first hearing in January, and we discussed it again when we were here in April. And you raise a point that there's an argument that one of the co-owners doesn't have any notice of this proceeding. And if I allow the building to be torn down, this city could have potential liability saying, hey, you tore my house down and you didn't tell me you were going to do it. The city has been quite successful recently in filling these abandoned lots with new homes. There are several within just a block or two of where this house is. I think 7 brand new homes have been built on these lots. Yeah. And so there's that. But now, as Mr. Klein pointed out, that there are homeless people in and out of there. We are in file 2216570N. Mr. Robert Dutka is here for Willie Thomas, one of the owners of this property on Jefferson Street. Timothy Reed is here on behalf of the city of Three Rivers. We took testimony from the building inspector, Joe Klein, that no improvements have been made on this property since April of 2020. Well, actually, since January, since the action started. Mr. Thomas has been paying his fines. He's come in and made several payments on it. Mr. Dutka, I frankly was happy to have him in the case. These things that he's describing about partition and appointment of receivership, A, those cost money, and B, there's difficulty with out-of-state service and getting hearing dates. So, Mr. Reed, what's your position? Certainly, Mr. Thomas, at this point, he can't sell the property because he doesn't own all of it. He can sell his interest in it. And there's still the question of Mr. Thornton being out there with some property interest in this property. What's your position?
Well, at this point, this started back in August of 22 when the first citation was issued to Mr. Thomas. Mr. Thornton was actually mailed a copy of a citation at one point. I don't know where he's at. He's not appeared. He's not showed up. At this point, we're still entitled to a compliance order. Mr. Thomas has the ability to bring the property into compliance. Just because there's a co-owner doesn't shirk his responsibility to have a compliant building. He can't say, well, Mr. Thornton's in Chicago and doesn't want to answer the door, so I don't have to do anything to the property. That's not how it works.
That's not how it works. Now, the problem is he can't sell it.
Well, but he can bring it into he can fix it.
Yes, he could.
He could fix it.
If you can find somebody to do that.
So attorney Dutka, attorney Robert, he's like, well, if once the contractor is spoken to about how intense or extensive the project is, it's more likely that a factor of financial ability, because contractors like, it's a big job, pay me a big check, I'll do it, atypically, but he didn't really attest to why they decline the job. but the contractors that his client has spoken to have declined the job. So he's like, well, if he can find a contractor to fix it, he can fix it. I don't know the financial position that the litigant is in. However, I do take issue with the fact that Attorney Reed is like, well, he can just fix it, because the whole point is he just got finished in his opening talking about if the properties repair and disrepair and its issue is over or is up to, no, if it's in excession of the value at 120%. So if it's 20% over the value of the property, then 120% over the value of the property, then they want to tear it down as the city. So the consequential thought process is, well, what about the owner? If the owner is assessing the damages and it's over 120% of the value of the property, he too probably doesn't want to make repairs. And maybe he wants to tear it down, or maybe he just wants to sell it to get from underneath it. So prohibiting him from remedy and just saying, oh, well, he can just fix it, when you already take note that that it's so disrepair that there's probably a valuation concern, he has the same concern as an owner. And so I kind of take a little issue with the fact that it's just, oh, just fix it. When Judge Middleton brings up a very good point, well, he doesn't have the ability to sell it because there's more than one person on it. And what Attorney Robert is trying to do is get the partition. Partition, of course, means separation. And that would be helpful, because if they can get the partition order in place and a receivership in place, that then it would give the other individual the ability to do whatever. Either he's going to fix it or sell it. And then if there's money that is in gains, you know, a gain from the sale after all of the fines and everything else is paid out, then they can go into the receivership for that particular owner that they haven't been able to locate or at least communicate with and get confirmation of service. When you don't have confirmation of service on a case, it makes it really hard for the judge to make decisions. So we're going to see how Judge Middleton wraps this up for the day, but I think they're going to get in a continuation. That's what I think, but we'll see what happens.
Again, that's not the city's, then it should be torn down. And he can tear down the property as well. He has a right to tear it down and deal with Mr. Thornton on the side. They're co-owners. Mr. Thornton wants nothing to do with it. This building is becoming an active nuisance in the neighborhood because of the fact you have homeless people going in and out. That was there at the first hearing.
Let me not gloss over that issue. That is a concern that the city is responsible for. Anything that becomes a nuisance or a communal concern or that can cause health issues by having homeless or, you know, persons that are not stable coming in and out of the building, an attractive nuisance such as that, that is the city's main concern, because they have to be concerned about the welfare of their taxpayers, which are the ones that are in the surrounding community, and their children. So that is understandable.
Despite the representation that can be saved, it's safe built. I don't want to speak for that, but the discussions we've had is it's a tear down. The cost of repairing that building would be equal to building a brand new one on that lot, if not more expensive based on the disrepair of this lot. And so at this point, I definitely can appreciate the logistical nightmare that Mr. Ducka and Mr. Thomas are fighting with a non-respondent in a petition action. We would ask that the court enter a compliance order against Mr. Thomas and against the property. We can then record that so it's of record that there's a compliance order against the property.
It also is another thing of record. They have a caption of this case that omits one of the owners. So if the owner is doing some type of background check on themselves or looking for unclaimed property searches or judgments against themselves or anything, you know, if you're being prudent, which you should be doing these searches periodically, running your credit reports and all that, and looking if you have any outstanding litigations, they will know, because they're not even listed in the caption, let alone you're supposed to have sent them a proof of service in the mail that I guess Robert is feeling like that person's not getting because they don't really have confirmation that they live there or something. I don't know. But that's very concerning. They should at least amend the caption to include the other co-owner.
And I mean, right now there has to be some secure, I mean, the city can go in and at least secure the property, board it up, make whatever action needed if Mr. Thomas isn't going to do it, to at least alleviate part of the nuisance until such time. If the court doesn't want to grant the city the right to tear it down, that's fine. We can also bring a nuisance action. Um,
Well, I'm gonna give you the
I
relief
feel
you're
good.
asking for, the compliance order. He may have an issue at some point with Mr. Thornton, but he's been ignoring everything. And
Oh, okay.
at some point, as I indicated more than a few times, this was a nice house. And it's a nice lot, as long as you don't mind living right across from the cemetery. It's right on the river. It's a very pretty location. And like I said, probably 120 years ago, this was one of the finest homes in town. But it's not now. It's a haven for homeless people. It's dangerous. It's affecting the other homes in the neighborhood. So, Mr. Reed, you may submit your compliance order.
I will prepare one and I'll submit it to Mr. Duca for his review to make sure it's approved as to his form as well, since he is in the case.
All
Thank
right,
you.
under the
Thank you.
7-day rule.
You're welcome. Thank you.
And I
Alright.
direct that it shall be recorded.
Thank you. I'll make it in recordable form.
Okay, so at least I have a report. Okay, so I was wrong. They're not doing continuation. He's getting the compliance order. Compliance is a notice order that says, hey, litigant, you must comply. Otherwise, you know, now you have an order against you and they're going to be able to accelerate to the other remedy, which I believe Mr. Reed said that they want to just condemn it and knock it down and move on. So they're going to give Robert's client the time frame to comply, and then the other owner who has not been responsive will get that in the mail again, I guess. And if they read it and do something with it, then they can come in and be represented in the matter relative to the property. So once again, don't ignore your mail. Open it up and read it. It's not going to jump out at you, you know, even if it's sad news, at least you know what the news is, because here's a situation where someone may be getting the mail and not paying attention. Judge Middleton said to make sure it's in recordable form. So this is good. So every county has a records clerk. And you go down there and you record your birth certificates, you record your death certificates, your marriage certificates, all of those things that are needed. They're called birth and vital records. And in addition to that, one of the most vital records is the transition of home ownership. So anything that goes against the title of the property, that identifies new owners, anything of that nature, gets recorded. So if you're in a transaction of real estate, you're like, I put my money in escrow, I signed every document, give me my keys. At the very end of all the process, your agent, if they're worth anything, they'll tell you you gotta wait a day. Or it used to be same day recording, but now a lot of counties don't have that anymore. You have to at least wait 1 day. And you have to wait the next day after you've paid all the money, the loan officer, the bank or whatever has paid all the money. It's all in escrow. Everything has been signed. You have to wait 1 more day to get the keys, because that's the time frame it takes to record. And what happens is you'll notarize the last document for, say, the 13th or whatever day today is. Sorry, I don't know what today is. Whatever today is. And then they'll give it to their processor to go record it with the county. And the county's like, okay, well, we'll record this tomorrow. Come back tomorrow. And so on the 14th is when they'll actually record. Once they record, now it's actually your house, your purchase. And that previous homeowner will say, come pick up your keys, or your agent will say, here, I have the keys to your house, whatever the situation is for that. And that's when you are the homeowner. So you never buy anything in between time. You don't put your, anything that pulls your credit, you don't do it. You don't get a new credit card. You don't extend the line of credit. You don't co-sign for anyone. You don't buy anything with your credit, because you don't want to mess up the process. All right, until you have the keys in your hand. Back to this circumstance. For those of you who are investors, this is like prime information, right? You're like, wait a minute, they're going to take over the property, because the city doesn't want property. They want safe haven for their community, but they don't want the property as an owner. They're not turning themselves into landlords. So down the road, it's either going to be that the purchase of the property, that the property is gone through compliance and complete, and the owners are fixing it. They've been paying their fines, so they clearly have some interest in the property. They're still interested in it because they've been getting fines by the city, but they've been making those payments. They're just in the acceleration stage of where the city is like, bring this up to code or we're going to take it over. So they get their compliance order. So the compliance order is like, comply, get this property up and to code so that it's no longer a nuisance, so that it's no longer a health hazard for the community, and that it can be brought to code and be used for the purposes of what it's meant for, which is, housing. For an investor, you're looking for some investors, they're looking for the homes that the city are in collection of, or better yet, because the lack of taxation, because the city says, we'll tear down the house, we'll board it up, tear it down. And then the judge said, well, who's going to own the lot if you tear it down? And they're like, well, the owners will still be the owners unless they falter on the taxes. If they continue to pay the taxes, then they'll just own the land. And so for investors, it's those individuals who are not making the payments on the taxes that become a very intriguing way of getting into real estate, because if you pay the taxes, then you can have proof of ownership, have the title change into your name, and then if someone's living there, you can make them pay you the what is it called, the rent to stay there, and you're not bound by the mortgage that used to be there because you own it, because the city has taken ownership because of taxation. And if you pay off the taxes from the city, then the city transfer that ownership to you, and you don't have to worry about whatever mortgage that particular house had previously, because that's not your contract, right? So what you'll hear, we had it in one of the cases, some of the landlords have a mortgage on the house and they're required to have an escrow account. Escrow accounts can mean different things. It depends on what the escrow account is for. Basically, it's the safe haven and collection of money in a secure account, separate and apart from businesses or any, commingled funds. And you open up a separate escrow account to do that with. Anyway, in this particular instance, the escrow account that they're talking about is the collection of taxes and insurance payments. And that's usually done for first-time home buyers. When you buy your house for your first time, or at least it's the loan that you're getting and you haven't had a house loan in about 2 years or 3 years. So you don't have to be the very first time, but it could be the very first time. Or if you're doing your second or third house, you don't have a loan open on another property for a few years. So when you get the first time home buyer loan, it's owner occupied, and you typically have an escrow account. And that escrow account in that circumstances for those insurance payments and then taxation payment, because if you don't, not because they're paying your taxes, but if you don't pay your taxes, right, because you're supposed to pay a certain time of the year, twice a year, if you're not making that payment and then it goes into some kind of default, then they'll pull money from the escrow account to make the payment. And then if you do happen to be in that situation, you have to pay the escrow account back and continue to pay the taxes to the city directly. It is an account much like a savings insurance account to ensure that if there's something that goes on taxation wise, the mortgage company does not lose their interest, because if the city takes over because of taxation, they will lose their interest. This house may not have a mortgage on it, but that's a nice long extended understanding of what some of the background is relative to this case. All right, moving on.
All right, thank you. Is there anything further we need to do on this?
No, Your Honor.
I don't know of anything, Your Honor.
All right, thank you. Mr.
Thank
Dunca,
you.
you're in a tough spot here. So's the
Poor
city.
Robert.
Yes.
But those 7 houses that have been built have done a lot to help improve this neighborhood. And you could put a fine home on this lot. So maybe that'll happen at some point.
I think Randall Brown could be a good receiver.
There
There
you
he
go.
is. Yeah. there
Put his name in there, and
Put
he'd
in
be
a
happy to get involved in this.
I'm not getting involved in this one, Judge.
I was going to
All
say, and Mr. Ducka pointed out a very good point, which is every receiver case I've had in the last 5 years, I think Mr. Ducka has been the acting receiver. So
Well, I was going to say, I was going to make that very point. We can't appoint you as the receiver because he does an excellent job for the courts. I don't know who's going to take that on when you retire, but yeah, we can't appoint you, but that would be the ideal circumstance.
It-
All right,
it-
we're
it
complete on
would,
that
yeah.
record.
all right, thank you,
So
Your Honor.
thank you.
Joe,
Thank you,
you're all
Your
set?
Yep, thank you,
Yes.
Your Honor.
Thank you.
So the receiver cannot have an interest, and so therefore they can't appoint Randall. But it sounds like Randall's so good at it, and he might have an interest in it because it's a prime location. This lot is important. So I hope the current owners wake up, because everyone is loving the lot. And Judge Middleton, I swear, I want to know if there's any block in his district that he doesn't know. So if you ever are a journalist in Michigan in Three Rivers and you know Judge Middleton, if you could just get a quote for him and ask him, is there a block or a section of his district that he just doesn't know? Because he has the historical content of the area. He's like, oh yeah, the new builds are in there. There's 7 of them. They're great. Call that construction company. That sounds like they could do wonders with this lot. Like he is definitely well informed when it comes to his township.
All right, Miss Miller, would you come up and have a seat
All right. Oh, she's
right over here? If you
podium.
would, thank you.
Okay, she's on. Okay, okay. There she goes. Hi, Miss Miller.
This is file number 222002, People versus Sharon Lee Miller, the people of the village of Burr Oak. This has to do with a property at 447 East Main. The allegation is people were living in an RV without utilities and they were dwelling there. That citation was issued by Vaughn Reed originally in October of 2022. We were here in August and we had a hearing regarding the compliance order. The court ordered in August that the property would remain, but they had 7 days to remove the RV or the city would do it. And we held off on contempt. Mr. Reed advised that the property was in the same condition it was when it started. And I set the matter for contempt review for today, September 13. Are you Sharon Lee Miller?
Yes, I am, sir.
All right. Mr. Randall Brown, the Borough Village Attorney, is here. Mr. Brown, what's the status here today?
Good afternoon, Your Honor. Good afternoon, Ms. Reed. Yes, the order of removal has been entered, and I believe a contempt finding was made, and we set a status review just to see if Ms. Reed would remove it so the village wouldn't have to. And Ms. Miller, because it would cost her more for the village to come in and hire people to remove it. Ms. Miller called me yesterday. I wasn't available, but I received her voicemail, which said that she was in the process of removing the RV from the property, which I was delighted. And I called Mr. Reed, the Borough Village Inspector, to check that out this morning. So I received a message from him at 9:30 this morning that the RV was still there. So I got in contact with Ms. Miller again, and she told me a tree had been in the way and that she was in the process, or her son was helping her in the process of removing the tree, and she would have that RV removed by 1 p.m. today. And she asked me if she had to come to the hearing, and I told her I had no authority to tell her she couldn't or didn't have to come to the hearing, and I'm glad that she's here now to resolve this. But that's kind of where it stands, is that the RV is still there. She tells me it's going to be removed today. I couldn't get Mr. Reed to go check to whether it had been removed, so maybe Ms. Miller will tell us. I hope that it has been. And I'll just end by saying that the village could go ahead and do this, but the village is still in the process of trying to get contractors to do it. It will be done eventually, but it has given Ms. Reed a bit more time here to do it herself, which I hope she can get done.
You called her Miss Reed a couple times. It's Miss
I
Miller.
apologize, Miss Miller. It's Mr. Reed is the village inspector. I apologize, Miss Miller.
All right, she wants to tell us something. What's the current status?
Okay, so before we get into the rebuttal on that, I want to give you a pop quiz. Just a quick one. You know, we can do this. It's not going to hurt you, okay? Pop quiz. What is the difference between this is attorney Randall Brown's conjecture at this time versus what we saw in Judge Simpson's court when the attorneys had to raise their hand and get put under oath in order for them to tell the status of the case? Do you know the difference? Okay, so some of you probably said, well, I don't know about Judge Simpson's court, whatever. Or maybe you have yelled it out and you do know the difference. The difference is the opposite, the opposing side is there. There's either the representative or in this case, the actual litigant. So Miss Smith, I believe is her name, she is on site. So the information that Randall is giving is not as a witness. Even though there was a lot of like, this is what's going on, and she said this, and I said that, and we did this, and then Randall Reed went over there, and he's giving a status report and kind of giving all the assertions relative to what has happened, who said what, when, those sounds much like testimony. He is still representing, he's there in a representative capacity for his client, and he doesn't have to go under oath, because now, since the opposing side is there, they can go up and say, no, Your Honor, he said half that stuff is not true, or yeah, what he said is true, and they can go ahead and confirm it. If she wasn't there, then they would need to put him under oath, take his statement under oath. Therefore, if they come to find out the information is somehow fraudulent or misrepresented, then he would be penalty of perjury. All right, that's the difference. See, that was an easy conflict. All right, let's see what she says.
I paid somebody yesterday to move a fifth wheel. I don't know who put it in there. What they did, they put the fifth wheel, when they moved it in, they put it
Wait a
in behind my big tree instead of in front of my tree.
Okay, I gotta go back because I
What they
can't
did,
understand her.
Fifth wheel. I paid somebody yesterday to move a fifth wheel. I don't know who put it in there. What they did, they put the fifth wheel. I paid somebody yesterday to move a fifth wheel. I don't know who put it in there.
It's funny, I can't understand what she's saying, so I put on the closed caption, and closed caption thinks she's saying the same thing I'm saying, put it on Israel. I don't know why that would be a case unless that's another township. So I'm not quite sure what she's saying, but hopefully we'll understand in just a second.
What they did, they put the fifth wheel, when they moved it in, they put it in behind my big tree instead of in front of my tree. So yesterday, we couldn't get it out, so we had to take a log chain and we had to pull the tree down before we could get the fifth wheel out. So my son, when I was getting ready to come over here, he's got two friends with a truck with a fifth wheel, and they was on the way to go over there and finish getting that tree out of the way so they could get the fifth wheel out of there.
Where are they gonna put it?
I'm taking it where I'm living at now, on
Over to
St. Joe
Bronson?
Road.
All right, and that's in Branch County?
Well, they call it Branch County, but my mail comes from Baroque.
All right, but it's I think that St. Joe Road, is that in Branch County? I think it is.
I guess
Yeah.
they just meant Branch County. But my son should be over there probably right now as I speak. Because the two gentlemen was on their way to pick him up as I was coming over here. They had to finish cutting the tree up and getting it out of the way before I could get my fifth wheel out of there.
You hear Judge Simpson kind of sighing. He knows exactly where it is. And so what's the issue? The county has an issue with this particular vehicle being on site. They said the reason that one of the part of the complaint in this case was that there were no utilities, so no running water, no electricity. It was just basically a vehicle that wasn't functioning, and they were leasing it out, renting it out, or allowing people to stay inside. And so that's a problem. So she's being required to remove it. But wherever she's going to remove it to, sounds like it's still within the same county. Be careful, city, county don't have to have the same names. I mean, so a lot of us know that. LA County is encompassing of several different cities and a very wide range of mileage. So that's where Judge Middleton is. He's like, oh my gosh, they're going to move it to a whole new place. We're going to have the same problem because, you know, it's the same county.
Well, you say it's your fifth wheel. Is it titled?
No, somebody just pulled it in there and just left it in there. Like over 2.5 years ago.
Is it usable or is it just to be scrapped?
No, it's usable. I was actually using it. I was putting my tools in it to remodel my house with. Nobody has not been living in that fifth wheel at all. I had
Your
all
Honor.
my tools in that fifth wheel. And when I even called Officer Miller down there and asked him to come down and showed him that all my tools was inside that
Well,
fifth wheel.
even that, you can't use a fifth wheel as a storage container in most villages and cities.
But I
So
didn't know that, sir.
the question is, well, there was a compliance order, and let's take a look at it.
But I know it will be out of there before today's over with. They just had to go down and cut the rest of the tree out of there and get the tree out so I could get my fifth wheel out of there.
Your
And
Honor, it's
I
not,
didn't know that till yesterday.
All right. Mr. Brown, do you want me to put her in jail for contempt for fail to comply with the order?
no, I don't want the court to do that, Your Honor.
Okay,
But I would like to have her get this done. The RV it cannot be used. It's in violation of code and nobody could live there. People had lived there. Ms. Miller knew about that. So there's no question that it needs to be out of there. I think
I
what
paid,
we would like is, Ms. Miller says it's going to be removed today. Ms. Miller, if I may ask Ms. Miller, what time today will it be removed?
well, I'm hoping it'll be moved before 5 o'clock. They promised me that they would get it. I paid them yesterday $50 to move it.
well, does it have air in the tires? They gotta be, does it have tires on it?
Yeah, it has everything on it, sir.
All right, so you can haul it down the road.
Yeah.
Probably
yeah,
doesn't have a valid
but
plate or anything, but,
When we went there yesterday, we didn't realize that the tree was stopping us from moving the fifth wheel. So what we had to do,
okay, I understand, but I
the
just
gentleman-
I didn't know whether they can move it, whether it's,
oh yeah,
All
it can be movable, but
all right, so you say it'll be moved by 5 o'clock today?
they had to take the chain, or they had to take a log chain and hook it to their truck and actually pull my tree out of the ground. And they was going back over to cut the bottom of the tree off
The judge doesn't care, he just wants to know the time.
so they could hook the fifth wheel up and move it out.
All right, which you say will be done by 5 o'clock
5 o'clock?
today?
Yeah.
All right, Mr.
They
Brown?
was already on the way over after my son to pick him up as I was coming over here.
All
Yeah, I
right,
think
what
I
does
did
that
submit
do?
I think
And
I
I
did
showed-
submit a picture of the,
They promised me that they would have it out of there by today. I already paid them. And I said,
Your
this
Honor?
is serious. I need it out. So I paid the money yesterday to get it out of there. But I didn't realize that the tree was,
All right, I got you. You told me about 5 times about this tree, but it hasn't,
And
that hearing was some time ago. And you're working on it. So in light of that, Mr. Brown, what are you asking for?
I believe today was to impose penalty for contempt, and that's why we scheduled a status hearing to put that off so that that wouldn't have to be done. So in light of
Yeah.
Ms. Miller saying it's going to be removed by 5 PM today,
I'm gonna get out of it.
Stop. Go ahead, Mr. Brown.
I think I'd like to give her the benefit of the doubt and say if that could be done, then there'd be no penalty. But to keep it over her head, I would like to have the court impose the penalty if it is not removed.
And
Per
what
day.
penalty are you asking for?
A fine to be assessed per day, every day that it's not moved.
All right, that was $150 today, per day. All right, if not removed by 5 PM today, defendant is liable for $150 per day.
I mean, I'm on Social Security. I'm 70 years old.
you better make sure they get it out today by 5 o'clock.
Yes, so that's all the more important for you to get this out of
I know I've
there.
been trying.
Okay, well, this action started in October of
I know.
2022.
I never knew, I couldn't.
Well,
find
stop,
anybody
it's
with
been
a
going
hookup.
on for 2 years, so.
And nobody even said nothing to me until after 2.5 years that it could not be set.
All
there.
right, well, you got,
Okay, wait a minute, Your Honor. He just said it started in October 2022. I'm still in 23. I don't know if he made it to 24 or not, but I'm still in 2023, so that's 1 year. But nonetheless, we've had sufficient enough time to take notice of the judicial requirement to get it removed.
got a citation.
So after 2.5 years that it could not be set.
All right,
there.
well, you got a citation back in October of
Well,
2022.
I didn't know it was illegal.
Well, you do now.
Yeah, I do now, but.
Well, all
I've been
right,
trying
so
and trying to
if
get
you'd have
somebody to
moved
move
this
it.
in October of last year, we wouldn't be here. But we went through multiple hearings. The village has spent thousands of dollars to get you to move this. I ordered that you moved it. I found that you're in contempt because you didn't move it.
But I've
I
been
said-
trying, sir.
I set it for a review hearing today. And so allegedly, it's gonna be moved today.
Well, if I can't get it moved today, I'm gonna cut it down and burn it up.
Well, you can't cut it down and burn it up there. You gotta get it out of where it is. And
I can't afford $150 fine every day.
well, could you afford 90 days in jail?
No,
Yeah, so I want you to comply with my order that you remove this. The city's been working on this since 2000, probably the
I
summer of
realize that.
2000 or 2022.
Well, I do know that they was on their way to pick up my son when I come over here. And they promised that they was going over there to finish getting the rest of that tree out of there. And they was gonna get my fence.
See,
out of
my
there today.
fear is they're gonna get that tree out of there. I'm gonna
They
find
already-
this,
Most of it's already
all right, that
removed.
this thing doesn't roll. That
They,
they're,
they jerked it out with a truck.
all right. Then if it's removed by 5 PM today, there's no sanction. If not, you're liable for $150 per day for every day that it's there and it's not removed. And you're also in a continuing contempt, which could result in incarceration, jail. So I want this thing moved. Now, this will become Branch County's problem, I guess, once you drag it over the line. But in most jurisdictions here in St. Joe County and the state of Michigan, you can't live in an RV.
Nobody has never lived in it.
All right, well, you can't. I don't know. How big is your property out there on St.?
I wish she would stop doing that because, well, you know, he's not snapping. He has great even keel. Both of these individuals have a lot of mercy for her. You know, Judge Middleton's like, look, you're already in contempt. The thing is still there. You already owe me days in court. I should be, you know, fining you a day. And Randall's like, you know, Your Honor, let's not fine her a day. She's going to get it out today by 5 or whatever. Everyone's trying to work with her, but she keeps clapping and snapping. It's like, girl, they're trying to work with you. Chill.
St. Joe Road.
It's a duplex and I've already talked to my landlord and he said I could take it out there.
All right, well, you're gonna
Perfect,
have a new
yeah.
set of problems because the landlord's not gonna want some beat up RV sitting there and then.
No, he said I could put it behind the apartment house and just leave it there until I sell it.
All right, well, you're gonna have a hard time selling it if you don't have a title to it, but
It's brand
nonetheless,
new, sir.
all right,
It's
Well-
a brand new fifth wheel.
okay, well,
Randall's like, no, it's not. No, it's not. It was brand new maybe when you put it on that lot, but it's not brand new today. It's no longer in brand new condition.
even
brand
so, if you don't have a title, okay, well,
It's not
even
brand
so,
Brand
if you
new.
don't have a title, you can't sell
I
it.
know, I know, but I don't even know who took it there.
Well, I don't know, those are issues you're gonna have to deal with.
Well, why not petition for the court? Well, I would say, you know, Judge, can you put an order, since I am being financially responsible and I'm being told that I must remove this property and I must deal with this property. Judge, can you put an order that this is my ownership, that I own this RV, here's the VIN number, and put down that I am the newfound owner. Then you go to DMV or whatever and have them record ownership in your name. Now, the situation may be that that thing may owe some kind of fines or financial responsibility to the DMV. But if you take the VIN number and go to AAA or go down to DMV and say, I have this abandoned property on my lot, I need to find the owner so they can come get their thing or relinquish their rights to owner so that I can resell it or whatever have you, they'll work with you. So all this, I'm not the owner. I don't know who the owner is. They just dropped it off, but I'm gonna sell it, but I don't have a title. I don't know how to get a title, but I don't know who they are. That's a lot of like circle and circle and circle. Let's get to solutions. Solutions would be get the VIN number and have an entity, probably the DMV, run the number see if there's clear of any fines. If it's a whole lot of money owed, then I take it to the salvage yard and tell them, here, you can have at it. Or see if Judge Middleton will put a court order that you're the owner because you're stuck with the thing. It's abandoned on your property, so make it yours and you go down and record it in your name.
But, and I don't believe that. I think you know who put it there.
No, I swear to God, you.
Judge Middleton is a hoot. Did you see that? His tonation didn't change. He didn't roll his eyes. It's just if he told you, you know, I love cookies. Remember the day he was looking for cookies or something sweet to eat? It's as if he came back and said, yeah, I found the cookies I was looking for. He's telling you, you're a liar and I don't believe you. But he does it so chill. It's so funny.
It's a brand new fifth wheel.
Okay, well,
It's not
even
brand
so, if you don't have a title, you can't sell
I
it.
know, I know, but I don't even know who took it there.
Well, I don't know. Those are issues you're gonna have to deal with. But, and I don't believe that. I think you know who put it there.
No, I swear to God to you, I don't know
It
who took it there.
just materialized on your property?
Yeah, I don't know who took it there.
A brand new mobile,
Well,
fifth
it's
wheel?
not, I can't say it's a brand new one, but the inside it's got a brand new refrigerator, stove, freezer. It's nice on the inside, but I can't say it's brand new, no, but it's livable.
Okay, well, all I want is to have it out of there. Take it to a campground
Well, I want it
somewhere.
out of there too.
All right, well, by 5 o'clock today, otherwise the clock is gonna start ticking on $150 a day. And the plaintiff can ask for additional hearing.
Your Honor, just if I may ask a question,
Yes,
just in terms of process, would the court like me to report in terms of whether it's moved or not by a report from the inspector?
yes, by
close-
the end of the
close the
week,
file on this?
by September 15th.
Just for the record, the RV is not livable.
Well,
Attorney Brandon was like, listen, lady, I'm voting for you. I'm rooting for you. I'm trying to prevent you from going to jail. I don't want you to have all this money racked up against you. You say you're getting ready to get this thing out of here, so I'm believing in you. But what I won't let you do is lie. He said, no, it is not livable. No, it's not brand new. He says, I want the record to be very clear.
you mentioned some pictures. I couldn't find any.
I thought in the complaint, compliance complaint, I attached a picture of the RV with the notice on it.
Oh, that's gonna be the notice. It's not really gonna show the whole thing, right?
Maybe there's one in here. It's. Yeah, there it is. It's sideways in black and white. It's got the canopy up. Yeah, it was condemned in
It's
October
never
of
really been
22.
livable. Not that I know of.
All right, all I know is I want it out of there.
I do too, sir.
Okay, by 5 o'clock today.
All
Okay,
right.
I'll give you till dark, but that'll be 7:30 to get it out of there.
I was
And
wondering.
I'll put 7:30 PM today.
Yeah, that's better. I did wonder that. I did wonder that because Randall said that they were starting the process at 1 o'clock. She never really gave a time on the record. Something that she reported to him during one of their conference calls. And so I'm like, well, if they're cutting down a tree, removing a tree, that may take a couple of hours. They need to take a break, get back into, actually hooking up the vehicle. And the judge has a great assumption. It's like, well, what happens once you find out the vehicle doesn't want to do something, that it doesn't want to go into neutral, or the wheels don't actually want to turn and the tires, are flat or something else of issue. You got to deal with that too, and then make it movable. So because you're not dealing with a flatbed, you're going to be haul away with whatever that, the pulling thing. So anyway, so now he's giving her to 7:30. Okay, I like that. That's a little better, but Randall didn't say anything. I wasn't gonna say anything. It's just bottom line, judge wants it gone. He said that so many times. Trust me, that's like his discerning and emphatic communication has a mellow sternness, but never really overly excited. So just trust the words that are coming out of his mouth. Okay. He wants it gone. He's not mixing words. He doesn't mean anything other than what he says. He wants it gone.
All right, go out there and see how they're doing.
Okay, I appreciate it.
The inspector's gonna come look at it. And this has been the checks in the mail, the checks in the mail. Anyway, it needs to get out of there. If you take it to the St. Joe Road address. Let's see where that is.
589 St. Joe Road.
Yeah, that's a Branch County address.
Yeah, it's right on the corner of US 12 and St. Joe Road. There's a storage shed unit in front of my apartment house.
Well, that won't solve the problem necessarily, but it will solve the short-term problem.
Yeah,
All right, go check and see how they're doing over there. If they get it out of there by 7:30,
that's
they'll
what I
report.
plan on doing as soon as I leave here.
All right, very good. Mr. Brown, anything further?
Nothing. Thank you, Your Honor.
All right, go out there and see what they need. Good luck getting it out of there. If it's gone, this thing's at an end. If it isn't, we're gonna have further hearing on the matter.
All right,
All right, thank you.
and I'm gonna try to get it out of there.
All right, Mr. Brown, thank you. There a lot of time and effort to get this thing removed, but maybe eventually we will. Yeah, I did have one picture, kind of a copy of a copy of a copy in black and white, but it may have some value if you could get it out of there and clean it up, but it doesn't have any value sitting in the middle of the village of Burr Oak. All right, let's hope they get it out of there. All right, you know it's there too long when the trees have grown around it, so you can't move it out. Which I've seen more than once. All right, thank you. Good luck on that appointment as the receiver in that Three Rivers case. And I'll see you soon. Thank you.
He said, no, thank you. He does not want to be the receiver. Okay, so
All right.
let's pause real quick. There is the QR code. Here is the website if you are so inclined to do the public satisfaction survey on behalf of the St. Joseph County, which is the county for which Judge Middleton presides in Michigan. Okay.
All right, those zoning cases have always got weird twists and turns.
Thanks, Judge. I love how he interacts with us on Zoom. He's like, hey, people, let me tell you more. So yes, zoning can be interesting because there's always a different reason, right? We had the chickens at one point. Chickens were a problem because they were getting into the neighbor's property. And then it was when they finally got the housing for the chickens, that became a problem because it wasn't so far away from one dwelling or the street sidewalk or the distance to that. Zoning can be a actual whole new thing, right? Depending on what you're trying to do with your property. So always ensure that when you're looking at your property, you talk to your real estate agent and let them know what you plan to do. Sometimes you don't know in the beginning because after some time goes, you're like, hey, I want to live off the land. And you want chickens, out of the blue. But sometimes you just don't know in the beginning. But if you do know, tell your real estate agent. They are not the authority, but you do, they'll be able to help you figure out who can let you know what zoning will allow. Or at the very least, you can get a general contractor to go down to planning department and ask them, in this R1, in this R2, or, whatever my property is zoned for, am I allowed to have livestock of a certain number or, whatever. Go into all those questions there. And Michigan state says you're not allowed to have an abandoned RV or an RV without utilities. And I'm not even sure if you're allowed to have an RV on personal property. And she may need to look and find out to see what the full law is relative to that. they may require that the RV is set into an RV lot and it's not on the personal property, even if it's your personal property. And I'm very confused because she presents like the house is her personal property because she was doing rehabbing on the house. She was using the RV as a storage unit for which the judge is like, you don't have to do that either. You can't turn it into a shed. It doesn't just all of a sudden become a storage unit. A very interesting piece of information. We found out a little bit more about Michigan law, but realizing that though these zoning representations is relative to that location, when I said, what's it, St. Joseph's County, and then they talk about Baroque County, and I think it was maybe one other county they spoke of. So whatever the case, it's in Michigan. So you have to look up what actually is relevant for you. But as an investor, if you're trying to look into different locations to do certain purchases, if you say, I want to buy a lot and I want to make it a RV parking lot, or I want to do a mobile home community, make sure you've talked and not just talked to, make sure that you have actually commissioned a general contractor to do the research for that area to determine if it is allowed to have those type of dwellings or lots in that area, because it's not a given that it can just happen anywhere. You have to double check before you make that purchase, and that due diligence is on you. Okay, so Judge Middleton he as you can see, he's still even keel, but when he does tell you he wants something done, he does mean it, right? He was not playing with her. No, I want it done. But he did avoid charging her the $150 as long as she can get that done today. By 7:30, he gave her even more grace relative to time frame. So she has a lot of grace and favor. She's been working on it for a year and she's finally getting something done. So hopefully all will be well. But like he said, it's just really just kicking the can down the road because you're going to move it to a new location, same county, and you're going to be dealing with this all over. Or you're going to be dealing with a problem if you don't have it under your name. So we'll see what happens. Well, we won't see what happens. Hopefully all will be well. That hopefully she won't come back into court. If she doesn't come back into court, that's good. That means that she's solved the problem, right? So we do wish her well. Lyric Armstrong, your real estate agent and advocate. Make sure you like, share, and subscribe. As always, we get to learn new things. And if you know everything, then great. But make sure you're sharing this out so someone who doesn't know can find out. All right, talk to you later. See you on the next video.